Good afternoon, one and all present here. Myself, Hiranshi Shah. I am the moderator of this webinar. I am the secretary of CIADR Gujarat branch. I am also associate member of Charter Institute of Arbitrator, United Kingdom. And previously, I also appointed as a conciliator by the District Legal Service Authority in the National Lok Adalat. Again, I welcome you all on behalf of Center for International Alternative Dispute Resolution. The CIADR of is an online dispute resolution center which provide a reliable and cost-efficient service since 2018. So now the CIADR is renowned for its fast-rating dispute resolution and very experienced independent arbitrator and mediator in South Asia. Some of you might have like some question that why is mediation has growing concept of alternative dispute resolution. So to solve this your queries and problems, the CIADR Gujarat branch hosts a webinar on ongoing trade of commercialization mediation in India. As you know, in 3 years ago, our Chief Justice of India, S.A. Bobde sir, said that now is the time is ripe to devise a comprehensive legislation which contain a compulsory pre-mediation pre-litigation mediation which would be ensure the efficiency and reduce the time of pendency of our party as well as courts. So now that much importance will be given to the mediation, and also we have compulsory pre-mediation in the commercial acts also. So before the starting the webinar, I will introduce our guest of honor, Ms. Ruchita Jain. She is completed her LLM from University of Sussex for United Kingdom. She is a mediator at CIADR and also the attorney at the Rivers Legal Firm. The Rivers Legal Firm is a law firm which based in India and having their branches in abroad too. It provides the service relating to the international trade law, arbitration, and intellectual property law, etc. Our speaker, Ms. Ruchita Jain, is also legal consultant at Permanent Legal Aid Clinic, which form under Gujarat State Legal Service Authority. I welcome you, ma'am. Before the starting the webinar by the ma'am, I will request you all the participants kindly switch on your camera for a while so we can mark your presence, and I kindly request to all of you to mute your mic and last in on your whatever queries we are taking in last 10 minutes. Thank you. I welcome you, I welcome you, ma'am, on this webinar.
Thank you, Hiranshi. Uh, can I start or? Okay, so let me start. Good afternoon, everyone. We are here together to discuss regarding commercial mediation in India and ongoing trend of the same. Basically, directly jumping on the topic, I would like to discuss more about mediation, what exactly it is. Point of discussion today includes participants involved in mediation, how it takes place, what is the process of the same, how it is evolved, and finally commercial mediation and how it is growing in India and various other legal systems too. So starting with, I would like to quote one sentence from Honorable Supreme Court of India, which states that settlement of disputes in an amicable way is the hallmark of any civilization. So in short, this is the basic concept of which is evolved from various countries, and it is imbibed in our ancient history in Indian society, in Indian legal system, at every places we deal. Abraham Lincoln also said that discourage litigation, persuade your neighbors to compromise, point out to them how nominal winner is often a real loser, and in fees and expenses and waste of time. In today's scenario, we all know that going to court or going for a litigation is obviously more expensive, more time consuming, and that is more frustrating at times. So, ADR, alternate dispute resolution, is a process, various other factors involved in it, which is helpful for each and every person in near future. Moving towards ancient roots of mediation. In India, as in other countries, the origin of mediation is obscured by a lack of clear history or historical background, and that is more or less because of colonization in India over past 250 years. but there is a scattered information regarding the same. We do know about a panchayat system in India, which is still persisting in India, an Indian legal system. Now moving towards in our Sanskrit there is a slok, Santosham Paramam Sukham, which actually means satisfaction is ultimate peace. So mediation is one of the modes of or attainment of peace. It is also propounded by Buddhism. People who are aware about Buddhism, they also knew that Buddhism propounded mediation as the wisest method of resolving problems. In words of Gautam Buddha, better than 1,000 hollow words is one word that gives peace. So, mediation is a process where we are moving towards peace instead of fighting for revenge or some other factors. Also, our ancient jurist Patanjali also said that progress comes swiftly in mediation for those who try hardest instead of deciding who is right or wrong. I agree that not all disputes are to be resolved through mediation. Few criminal offenses or other things we cannot resolve through mediation. But there are various factors like family disputes, matrimonial disputes, commercial disputes, some service disputes, which we can obviously solve through mediation. Now, going further about mediation in India, how that is being added in India. Mediation, conciliation, arbitration, negotiation are all parts of alternate dispute resolution, and that has earlier forms of historically more ancient than present day Anglo-Saxon adversarial system of law. Mediation and arbitration gained a great popularity amongst businessmen during pre-British rule period. The Mahajans, who were like businessmen, who were respected, impartial, and prudent businessmen who used to resolve the disputes between merchants through mediation since long. And this type of mediation had no legal sanction in spite of the wide common acceptance in the business world. So that is the basic factor when mediation started in our ancient system too. Now, what is mediation process and participants involved? Mediation process, in simple words, very simple words, there is always a conflict between two or more parties, and a mediator who is a neutral party to the conflict can act as a mediator to resolve the disputes between them. But mediator needs to check that there should be a win-win situation for both the parties. So satisfaction is of utmost importance over here. Now, going towards mediation in Indian legal system, mediation first came to be legally recognized as a method of a dispute resolution under Industrial Disputes Act 1947. After that, there was an amendment in 1999, and Section 89 of Civil Procedure Code also discuss about the same thing. There is Arbitration and Conciliation Act separately formed for this thing, and later a central authority was formed by the Indian legal system. Indian legislature made a headway by enacting a Legal Service Authorities Act 1987, under where it constituted a National Legal Service Authority as a central authority which took care of all other this alternative dispute resolution policies. And the basic things which they took care of are like to encourage the settlement of disputes through ADR, through various like arbitration, conciliation, negotiation, and mediation, to lay down policies and procedures for making legal services available in the conduct of any case before any court, authority, or any tribunal, to frame most effective and economical schemes for the purpose, to undertake research in the field of legal services, etc. There were various other factors too, which gave rise to this act and which prepared this central authority to help others. Now, moving towards commercial mediation. Uh, Mediation in commercial disputes is not very a separate or very novice concept. It is already available in our system, but we have to term it as a mediation in commercial disputes to explain it in a bit better way. Um, there is a statement by Francis Hodgson Burnett which says, at first people refuse to believe that a strange new thing can be done. Then they begin to hope it can be done. Then they try, well, see it can be done. then it is done, and all the world wonders why it was not done centuries ago. This statement simply says that when we are going for a mediation, we see wonders, how it takes place, how it is less expensive, how it is less wastage of time, and how it is beneficial for both the parties. So this is the outcome. The outcome which mediation gives is something which is very useful for all the people. But since long we could not understand. At initial stage, mediation was not considered as a proper place of justice or something, because people used to think that it is not that legally binding, it is not that effective, and other factors say. Laila Olapalli, a full-time mediator in India since a decade, she also stated that the parties are habitually adversarial and the current level of awareness is not sufficient to quell the burning fire of revenge and validation that they hope to achieve in the adversarial system. So, still, at this juncture, too, people believe that going to court and taking revenge is the better policy than going for a ADR and going for a mediation and other things to help them. And the basic reason behind this is they want to take revenge, or they want to get the other person punished, or they want that compensation and other things. And since that is the reason, they still think that ADR is not a proper platform to gain justice. Now, India. India is a powerful emerging economy, as we all know, in a rapidly globalizing world. So, unprecedented expansion of technology and more frequent international business partnerships have necessitated collaborative dispute resolution mechanism. It is therefore extremely pertinent to locate and cultivate commercial mediation in Indian legal system to attain this economic wellness. As corporate entities in many countries are increasingly expected to secure positive settlement outcomes at lower cost and limit conflict resolution budgets. Mediation is becoming the preferred method to resolve disputes. This ought to apply in India too, given the sea of existing commercial disputes and those impending. We all know that commercial disputes are rapidly increasing day by day. We have a long list of pending court matters and litigation. So that is the thing which we are going through for mediation in commercial thing. That would be helping businessmen, that would be helping international business, commercial disputes to resolve amicably. So both the parties are having like wasting less time and wastage of time and other things. Uh, at last, I would say that though I belong to legal fraternity, I am a lawyer, and still I would say the lawyers are one of the most important factor that is hindering the growth of mediation or commercial mediation. And the reason behind is the lack of encouragement and support from lawyers has significantly impeded the growth of commercial mediation in India. This resistance has stemmed from lack of knowledge of the process and virtues of mediation, anxiety about loss of control over a case, over submitted to mediation, strong preference for advocacy, or fearing of earning reduced fees due to reduced billable hours, and various other factors. These are the factors which lawyers are taking into consideration to not to resort to mediation process. But we need to understand that mediation is a thing which would help ultimately everyone, even lawyers or parties involved with the conflict would also be helpful with the place. I personally, I am mediating at this legal service authority, Gujarat State Legal Service Authority, formed under government since last 3 years, and I have been dealing into various other mediation processes regarding family mediation, dispute, um, commercial disputes, even service matters disputes through mediation, and frankly speaking, I am more satisfied with the mediation I have successfully done and settle the matter instead of those matters which I am fighting in the court for justice. So, commercial mediation generally requires mediators and lawyers to apply a distinct skill set. Finally, I would like to suggest for mediation process. The commercial mediation generally requires mediators and lawyers. So, the lawyers should apply a distinct skill set, have familiarity with the basic concepts of commercial law, business operations, how it takes place, and basic functioning of the same, broad functioning of commercial entities to understand how this dispute took place and how a mediator could help them to resolve this conflict. through mediation. But the most important thing which I would suggest is that being patient is the skill which a mediator requires. A mediator, only knowing law is not sufficient. Being a mediator, you need to be very patient listener to understand the concept, to understand both the parties to the conflict, give them a comfortable ambience so that they can open up with their disputes. And at last, you need to provide a as a mediator, you need to provide a win-win situation, be it a commercial dispute or any other dispute. But provide a win-win situation to your party so that a dispute can be resolved amicably with the help of both the parties. So that is all. Any queries? Just let me know. Thank you.
Thank you, ma'am. So, as ma'am conclude, I want to just say more further in regard this. As ma'am said that yeah, mediation is growing concept, but there are some hindrance in that parties are not ready to settle case in mediation. So, as of now, I want to share my one of experience as I work as for a 1 year for Indian Mediation Week, which is supported by Ministry of Law and Justice. And so in that I aware more than 10,000 people regarding mediation. So like while I going to aware the people, they are like might confused with the term that are you talking about mediation or meditation. So like people are not actually know the actual term what is
Hmm.
mediation. So and due to this COVID, now the all the high court proceeding, Supreme Court proceeding, and district court proceeding were going on online dispute service. So in that, our recently our Gujarat High Court organized one online national lok adalat. So in that, I play as a role of a conciliator, and I solve more than 500 cases. So in that, we are actually doing that. We are firstly as to the best thing is why people believe in litigation. So I believe that once you have to tell the people that what are the benefits of the mediation, they surely come up with to solve their dispute in mediation. Because the actual people, the laymen are not aware what is the mediation. They are only know about litigation. They believe that litigation will provide a 100% guaranteed result and have some enforceability. They are not know about the enforceability of the mediation agreement. Even don't know about the competence of the mediator. So when we aware the people to regarding this, so we will surely achieve the result as we want. As we know, in India there are across the 100 plus statute which give a recognition to mediation. As of some, I would like to list it as the civil procedure code. Then second is in 2018 we have amendment in commercial mediation acts which mandate the pre mediation clause for every commercial dispute. The best is that this why this statute is given the compulsory pre mediation. So is like given we commit to people that it is necessary as to is an alternative and best way alternative for the litigation. There we accept of it. We have a part of list as Hindu Marriage Act, Family Court Act, Legal Service Authorities Act, Special Marriage Act, Protection of Women from Domestic Violence Act, even Court Fees Act. Also, Indian statute provide the concept of mediation. Apart from this, Companies Act and we have also Companies Mediation and Conciliation Rule 2016, which would mandate that under the section 442 of the Companies Act, there is a setup for a mediation and conciliation panel, which state that for mediation between the parties during the pendency of any proceeding before the central government or tribunal or appellate tribunal. So it mandate under also Companies Act to set up a mediation and conciliation panel. So how much that central government and the Indian statute given importance to the mediation, but we have some lacuna as people are not aware about it. People don't know the main thing is benefit about it. So we have to aware them. And we all know that recently the India signed a convention on Singapore Convention on Mediation, and India is also signatory country of this convention. We know that Singapore Convention on Mediation provide an international agreement regarding the mediation and recognize the mediation settlement. So in very near future, India also adopt a mediation regulation in this regard. As of now, we don't have any regulation, as we don't have any act particularly on the mediation. We have a rules, but not a act. We have a act relating to only arbitration and conciliation act, but we have rules, as we have to which mandate for every court to mediation. We have also the concept of court annexed mediation, that in whatever family dispute case, or any commercial dispute, or any pre-litigation cases would be also they will handle, they will go for the mediation. The court refer their case into court annexed mediation. So main benefit is what, that if their case will be solved in mediation, court annexed mediation, or in via lok adalat, so they have to refund, the client will get a refund fees of the court fees, which is the main important thing. They are not aware about it, that they will if even though they file a litigation, file a case in court, even they solve that case in mediation or court annexed mediation or via lok adalat, so the main important thing is their court fee will be returned by the court on this whenever they solving the issue, solving the dispute. And the main important other thing is that a degree of the if a person solve the dispute in lok adalat, so it will be recognized as a civil decree of the court. So without pay a single penny to any to the court or any advocate, the client will get a speedy justice. Also, they don't spend a single rupees, as they don't provide advocate fee, don't give to court fees, or even they don't have to like wait for such a long year. And we all know that litigation is not come up in one stage, as to appeal pay appeal, and more years will be as to district court, supreme court, and high court is a long process. Even is not a case that will be completed in one thing also. So this main thing, as if you solve your case in lok adalat or mid court and ex mediation, it would be also the binding on the party. They can't challenge in any court. The main thing is that it's not challengeable in any court. You don't have to pay any fees to the in the court, or in the in to the court, or in advocate, and you don't wait for such a long time. So there this is the benefits that you must all know about this regarding the mediation.
That's what we are saying here, Anji. But the problem is that lawyers are not encouraging people regarding the same. That is the basic
Yeah,
thing. I mean,
yeah, they
awareness
were.
is actually very low. And you told about this meditation and mediation. I would like to quote one statement from Lord Buddha. He said that meditation brings wisdom and lack of mediation leaves ignorance. So know well what leads you forward and what holds you back. So which is added to your wisdom. So that is the thing. Even Buddhism respected that there is a mediation and meditation are quite similar, but still they
Yeah.
have some different concepts.
Yeah, and the best outcome is mediation, as ma'am stated, is win-win for both party. And the mediation is the one of the mode for achievement of a mental peace and peace. The main thing is like even litigation, one party will win and one party will defeat, and ultimately they don't get the mental peace, or such even not for in very short period. The mediation in such a way that it will give you a win-win situation and give you the peace.
True, but that people needs to understand.
Yeah, and also the our like fraternity, as law fraternity also understand this concept, that it's not a thing that we can and only and advocates only like solve the dispute while litigation. They can also, they have to encourage this concept. It's like as of like in online the lok adalat, some advocate also distant it that to not to solve your dispute in lok adalat, or as
True.
these and that. So they are not, and even though even their clients or people like want to do their solve that dispute in this situation, they're restrained from the opt this process. as they will think, might be they will think that if the his dispute will be solved in first or two meeting, so how we will what about our fees or many things like that the under the mind of the lawyers. So yeah, lawyer have to also like have to promote this concept. It's not just a thing as mediation will cut down their monetary.
Exactly. And when we are talking about commercial disputes, so and especially like India being a like technology hub and various international companies coming down to India for various kind of businesses. So we require a proper legislature or something on mediation which can help them to resolve their disputes amicably instead of going to court. So even international companies are quite like they are beware of going to coming back to India to work because they are quite scared of going into litigation in India, which takes long years and too much of money and other things.
Yeah, as of now we have just mediation rules as it form under the one of the landmark judgment of the Salem Bar Association versus Court of India. In this case, we all know the our Chief Justice had opposite that there is a possibility to enact the Indian Mediation Act, which will be take care the various aspect of the mediation in general, and then after the Supreme Court had requested to MCBC Mediation and Conciliation Committee to prepare a draft model rules for alternative dispute resolution and also draft the rules for mediation under section 89 of the Civil Procedure Code 1908. So there is a very landmark judgment regarding as to the Supreme Court ordered the mediation and conciliation committee and the draft rule. As of now, we are only the courts are following this rule only, as we have no legislation or as a particular act on mediation. The courts are following this civil procedure ADR rules and mediation rules 2003. They are prepared by the MCPC. The most important, there are two parts in this rule, as the first part will lay down as the procedure to be followed by the parties and the court in the matter of choosing the particular method of ADR. So they have free to choose the whatever method they want to choose as an ADR. The ADR will not as a one method of there are not only one mediation as a alternative method. We under the ADR we have a arbitration, conciliation, adjudication, negotiation, and the lastly the mediation. So in this rule, mediation rule 2003, there is one part constraint that the procedure to be followed by the court and the parties, whatever the method of ADR they want to choose. And the second part consists that the mediation under section 89 of the Civil Procedure Code. So this also draft they called mediation rule 2003. So in that the rule 4 defines what is the mediation. Then rule 11 most importantly state that the mediator not bound by the Evidence Act and Civil Procedure Code. So this main thing, as in litigation every advocate and every party and the court will follow the rules of Evidence Act, Civil Procedure Code, Criminal Procedure Code. So in the mediation, what the lengthy procedure will be solved in short time, as the mediator are not bound by Evidence Act or Civil Procedure Code or criminal procedure code. So it will also the main benefit of the. And also we have some time limit as to completion of the mediation, which is most important, as in litigation not any single case will be solved in just 1 year or 2 year. It will take the a lot of time, but there is a time limit for completion of mediation, that is on expiry of 60 days from the date fixed for the first appearance of the party before the mediator. So this is the mandate time limit which were provided by the mediation rules and which are followed by every court and every party and every lawyer. So we have to take care all of this, and we have to aware the what the when the parties will ask their lawyer that why you should not refer my case in mediation. When that day will become, the surely the people will get the result as to in very short of time. As of that, to achieve this result, we have to aware the people, as we have to don't think as what we will get, as we aware the people of mediation. It's not just we have to aware the people regarding the concept of mediation. When we have to, people will come in this process when they will get the benefit. Main thing is benefit. Peoples will attract as to know what benefit I will get. So they, when they will know that what the benefit they will get, as the speedy justice, as is just in 60 days, then no, they have to don't any pay fees, any court fees, or if they solve their dispute in lok adalat. So it also the method of alternative dispute resolution, which will be solved by the as a is in mediation or conciliation. So they also do, they it consider as a civil decree under the State Legal Service Authority Act. So when we, the people, the general people, the layman will know about this concept and the benefits and the what the actual thing is going around. So they will also they have to prefer this concept as a mediation.
So, so is there any queries?
Anyone have any query, they can just write in chat box, so we will take one by one. Anyone if have any query, just write it down, otherwise we just wrap up this webinar. Okay, thank you
Or
ma'am.
else
I
people
think that
can also mail
audience,
us.
yeah, I think so,
Hiranchi, if
yeah,
anyone have any query, they can just email us and we can respond. You can
yeah
just
ma'am,
provide my email ID.
yes ma'am. Just you let's say tell the email ID, so audience can write it down, and they can in future they have any query or any question regarding mediation, so they will contact you.
Yeah, sure. It's Reverence Legal, REVERENCE, Reverence Legal @gmail.com.
Anyone have any query relating to mediation or any ADR dispute, they can anytime contact, in after future they can contact Ruchita Jain ma'am for their query. They will solve your
Sure,
queries.
sure.
Okay, thank you audience, thank you Ruchita ma'am. So we will
Thank you.
I also thanks to the CIADR to give me this opportunity to moderate this webinar. I thank you all of you. So as of now we conclude this webinar. Thank you all of you,
Thank
thank you
you.
all participants, dignitaries of CIADR, and our speaker Ruchita Jain ma'am. Thank you ma'am.
Thank you.
Have a good